Good morning and welcome to ITI's event on the Data Governance Act proposal. This is Guido Lobrano. I'm Director General for Europe at ITI. And I'm joined here today by Malte Beyer-Katzenberger. Malte is the team leader in the DG Connect unit on data policy and innovation. This is a public webinar. You can only see the speakers on video and myself. We have already fairly good group of people that have joined and some more are joining. So we'll give it another minute. I'm sure that many of you have seen the proposal that the Commission has published yesterday. It was long awaited. Many of us have spent some time reading through that and looking at the different sections of the proposal, but obviously there is nothing like having an overview from an insider, and Malte is one of the authors and main drivers behind the proposal. So we're very happy to have the possibility to have him here with us, and I'll invite him to give us an overview of the content of the different sections of the proposal. It is a very broad document that touches upon a number of issues. It is, of course, very important for an organization like ITI that collects a number of global tech companies, but is, of course, I would say, very important for the industry overall. And on that note, if that's okay with you, Malte, I would turn to you and invite you to give a presentation, after which we will have time for a Q&A. At the bottom of your screen, you will see a Q&A button that you can use to submit your questions. There is no possibility to ask questions live, but you can write them down and we'll be happy to read them for you and invite Malte to reply. This event, as I said, is public and is also being recorded. So without further ado, Malte, thanks again for joining us today. We're looking forward to hearing from you about yesterday's long-awaited proposal. Thank you.
Thank you, Guido, and thank you, colleagues at ITI, for giving me the opportunity. This is the first opportunity actually to speak publicly about the Data Governance Act proposal after the press conference, which was around lunchtime yesterday. I will try to make it fit for those who have not had time to read the proposal. I will also make it right for those who have maybe read the leaked document that's dated some time ago, and maybe you did your compare versions and saw what has been changed. I saw some tweets about that. Let me first say this is also very exciting for us because it's the first legislative proposal after the data strategy. The general conception of this first proposal is to say this is to support data sharing, which is possible without modifying rights on the data. So that's mostly voluntary if you are in a B2B situation or in a consumer to business situation, voluntary data sharing. We also will speak a bit about public sector data of a special kind that come next to the Open Data Directive. And with this, the ambition is to unlock value by more digital collaboration through data sharing. I mean, these were the terms we have used now throughout the past, I would say, 2-3 years in different communications. If for those who follow us a little longer, I'll try to also show you how there's a certain logic between the different things. But data sharing, I think we pushed the subject to the height of the agenda. And for us, data sharing is important because it allows to leverage the power of data that already exists without necessarily spending effort and money to create new. So let's recycle, so to say, let's reuse the data that already exists. And certainly let's not recycle it for free, but find arrangements where you can actually monetize on data that already exists. And that's at the heart, I think, of one of the ideas which are now going into this proposal. The second transversal notion for this proposal is that we need to further work on standardizing, in the broadest sense of the term, approaches to data sharing. I mean, a lot of data sharing happens. It's done custom made, it's use case specific, but it's possibly also a bit burdensome because for each use case you invent mechanisms and tools and contractual rules that underpin such data sharing. And I think progressively we want to come to a situation over the next 5 to 10 years where this becomes really a standard practice in companies, and there's also standardized procedures, which really drives down first the transaction costs. The second thing is then, next to the transaction cost problem, there's also a trust problem. Many people, or companies rather, would hesitate to share because they're not sure whether they can follow their data and can really assure themselves that the data will only be used for the use cases that they agree to. And there's an enforcement problem also in the broader sense of the term, to see how can I see whether my contract was actually complied with. Sometimes I can't, don't have the means to investigate what's happening on my business partners and inside his own business dealings. So really a question, how can I trust it? But there's also a trust issue, I think, in the players that would play an instrumental role in the data sharing. It's trust / also the question of a bargaining power, whether you can actually negotiate certain terms when you engage in data sharing. Maybe the third transversal point, you had heard that the Commission likes to see the emergence of common European data spaces. For us, the common European data spaces are mainly an organizing concept, rather than saying this will be this or that platform like we have it in the European Open Science Cloud, already quite, I would say, tangible. For us, the concept of data space means a set of technical and legal arrangements that make data sharing among a number of players, which is in principle open, easier. Whereas the rules, the technical and also the legal rules could come from legislation, like the one that we're just presenting, but also certainly from private law rules, multilateral contracts, even codes of conduct where everyone in a certain setting agrees to certain behaviors. And that then would be underpinned by technical infrastructures. And here also in the data spaces, and we'll get back to that when we look at the proposal, there are certainly two categories possible in how to organize that. One is doing it peer-to-peer, and if you heard about Gaia X, this seems to be very much the notion of Gaia X, that you basically take the systems that exist and you build an interconnector infrastructure, which is more like a browser plugin that can be deployed in any target system without that you have to make recourse to any specific type of platform or any type of player that helps you in the facilitation of the data transactions or the data ecosystems. But we also see use cases where it may be advisable to make recourse to a data institution, to a specialized service. I'm saying data institutions because the UK Open Data Institute has coined that term. And we also take some inspiration from their work to say that if we want to have data collaboration and data sharing works, in some situations, it will require a distinct player to do this. And preferably this distinct player is a third party, which is neutral and has no own stakes other than organizing a data sharing transaction or an ecosystem. And we'll get back to that as well. So the two approaches to organize a data space are, for us, completely valid, and we can support them now with this proposal in two different ways. But also to say that this proposal is not limited to establishing the data spaces. Actually, you will not even find, I think, the term common European data spaces much in the text, because we say this applies to any data sharing or data reuse situation that you can imagine, and whether that happens into something that calls itself European data space or not, actually it shouldn't matter. But if either the Commission fosters the emergence of a common European data space in a specific area like health or climate change or else, we would build on this proposal, and we also would invite the market participants who say, well, now we can also organize our own data space, so let's say mobility or industrial data sharing among ourselves. We don't need a Commission for that. That's also very fine, and maybe then also the elements that we build here are useful for you. So all of this, first, like overall bottom line is to say we want to make more data available because more players feel that they can make it available in a safe manner, voluntarily again. Maybe a final remark, is this limited to non-personal or personal data? You will see in the proposal that it really will depend. In principle, all the data are covered by the proposal as such, but in the different subsections, we solve problems that are maybe more prominent still in the space of purely non-personal data. Let's not even go to the mixed data sets, where I think the dominant view is that whenever you have personal data mixed in somewhere, you have to apply the rules of the GDPR to the entire data sets, at least wherever you can't really separate the personal data from the non-personal data in any way, because the database would allow you to do so. So certain problems are solved by GDPR, and we really where we're working closely with DG Justice not to create any new layer or any new problem. Rather, as we will see under the data altruism part, we will probably slightly operationalize one specific way, which was a bit maybe not fully defined in the GDPR, and we will get to that. So the three, let's say 4 blocks of the proposal are reuse of certain sensitive categories of public sector data. Second, novel types of data sharing intermediaries. Third, how to foster data altruism. And fourth, building European structures for a governance of standardization. Let me start with the first one. And I'll try to, speak for another 10 to 15 minutes on the entire 4 points. And then we can go into the discussion. The first thing is, this is a complement to the Open Data Directive, which is really about data that you can just put out there on an open data portal, and you don't ever have to mind who picks it, because it's non-personal, it's innocent data, it's weather information, it's mapping information, which shouldn't be secret anyway from anyone. And that's covered already under the Open Data Directive. What we couldn't cover under the Open Data Directive with that logic so far was data where third parties have specific rights, and that is rights of individuals, data subjects, and that's rights of companies in the confidentiality of the data that they had to provide into a public sector database. I mean, financial institutions know what I'm speaking about, a lot of financial supervisory data. And what we were then basically ending up with is a situation where that data stays safely in the public sector database. But what we try to foster here with the proposal is situations where you can use novel approaches or techniques to permit pattern detection in databases in a big data style, or maybe even do machine learning, where actually the desire of the benevolent reusers is not to actually expose any individual data information in the database, but really to train an algorithm or do some pattern detection for statistical indicators that can be derived from a public sector database, maybe in correlation with other databases. And this is really the important, I think, element in to understand the enhanced use of public sector data. So you see safeguards, especially in Article 5, that say, well, never ever IP should be compromised, never ever trade secrets should go out as a result of this, and also never ever actually personal data should go out of the systems unless the right holders or the data subjects have given consent to this. There's a specific provision in Article 5 for that effect. Wherever it's a public sector body to actually facilitate the obtention of consent. And that's a really practical question, whether it can be achieved maybe with the legacy systems that we have, not so much. Maybe in the future we will build systems that are able to actually also make people then opt into certain data uses. And it bridges to the data altruism discussion that we will come to. So this is really to allow certain processing. So that's why I think for me personally, the heart of the proposal is the secure processing environment, which is something we borrowed from the statistical community, where access to statistical microdata is already possible in many statistical offices for a number of years, including our own Eurostat, but also the French and some German and Danish and Dutch statistical offices, I'm correctly informed, where you have actually what we could call a safe reading room for the data. So a virtual environment where, or maybe even a physical environment where you have to come on premise, where you can do certain data calculations under tightly supervised conditions, including the verification of the results, but where also something would be possible short or midterm, which in the open world is called bring the algorithm to the data, so that if you have a querying algorithm, you could maybe even have it verified by the relevant public authority and then execute it on the data sets, which again, with a verification of the output, so that no smart algorithm can actually disclose any sensitive data. This is now a call on the public sector body, which we will see how they will react to when we go into the council discussions, to actually increase the efforts. So it's evident that not every county hospital or county library will ever have that system and the data scientists sitting near to it to actually verify all these fancy things. But that's why we establish competent bodies under Article 8, which shall help then wherever an individual data registry owner which can be a national database, but also a very local database, is just not able to do it. And then it will take time, but you will have to have data scientists also on the public sector side that can ascertain whether the data can be used in a certain restricted and limited manner, or it can simply not, and it will not service the reuser. But we're confident that this is possible. You have maybe heard about the French Health Data Hub, which has been in the press also for other reasons recently. You have heard maybe about the Finnish Data Permit Authority, FinData, and you may have heard, if you are from the German backgrounds, about the approach of the Forschungsdatenzentren, of which there are 38 attached to registers of different size and content. So there are now really this idea that you can do data reuse differently. So you don't have to say, send me a copy of the data and I will do something with it, but rather can I do certain limited processing environments on the public sector data. That's maybe the first batch. You will see a FIFO, a certain process that builds a last, I would say, safety net for whenever it is legally possible under GDPR or with the permission of the rights holder, that actually the full data set goes to someone, which we call the reuser. Whether what restrictions could you possibly add? And here to land this, there were, like we say, two positions on this thing. So should really data that is held by European public sector bodies go out? And if so, where should it go? And is there maybe also a duty of care or a certain responsibility of the public sector bodies to keep the data still safe? Especially when we speak also about anonymized data, could there be a risk of re-identification, as Max Schrems identified already in a discussion with the commissioner 2 days ago? And that is also all very acknowledged. For this reason, for specifically sensitive data sets that will remain in future legislation, and look, for example, for the planned legislation on a European health data space, we will then define certain highly sensitive data as a future-looking concept. And for these highly sensitive data, once we know what they are and why they are sensitive, we can also then establish specific conditions in a delegated legislation. Why is it so complicated? Because our trade colleagues reminded us that we have obligations under WTO, which are national treatment rules, and you can really only restrict data reuse by non-European actors with very specifically justified reasons. And for that, it was simply not possible to define these across the board for all public sector data that we had in mind, starting from health and hospital data information, going all the way to maybe labor statistics and similar things. So here we have, I wouldn't say postponed the problem, but we will tackle the problem when we really identify the type of data sets which we would like to see more reuse of in the public sphere, and then define conditions that are responding to the exact worries that these data sets pose. That is also the discussion that you may be right about in the press, that we were going for data localization. I mean, you don't find this word anymore in the proposal, but the discussion may still arise in the future when you say, well, now this type of data, we really think it should only be processed in Europe, and we can argue the case well also in front of a dispute resolution body under the WTO. So we will discuss that once again when we see the type of highly sensitive data a bit more clearly. But it was, I can say, was rather a big concern, and seems a broad concern also among politicians, not only inside the Commission, but in the member states as well. I'll move maybe to the second item, of which I'm personally quite proud, which is now the notion of the data sharing intermediary. Now, this is a notion where we say you need maybe specialized parties that help you in transacting data. The most easy one are maybe the data marketplaces style, I would say DAWEX, or Amazon has one, or bigger players have one, Ocean Protocol. There are emerging players here on that market to facilitate secondary monetization by companies. But it's also going then to the question of data trust, which feature prominently in the AI strategy of the UK, but also under a different word, and the French AI strategy, where you say, well, how do we actually build the data pools in Europe when the data are just not in one hand? So here, walled garden players have a bit of an advantage because they have already quite a chunk from different services of data in-house, so to say. if you want to organize industrial ecosystems without setting the mega platforms for manufacturing, for car, for agriculture, for other services, maybe we should work more on a peer-to-peer perspective, or with dedicated players that organize such data pools in a form of a data trust or other legal form. It shouldn't matter so far, but what should matter is that we shouldn't now nourish maybe a mega platform with monopolizing questions by design. So what we're saying here is that we want these players to emerge, but also to be respectful of what we would call maybe data sovereignty of all the participant parties. So it's not about creating a new platform that hoovers up data somewhere and says thank you and goodbye, but rather that we find structures to ties assets and also can assure that they have a direct return on anything they put into a data pool, because they have a stake in the organization, or because the organization actually organizes in a way as a service towards the data holders or the data providers of today, and doesn't want to replace the data holders today, but is more as at their service and allows them data monetization, either in bilateral exchanges or in pooling situations I just described. And these are these data sharing service providers that we're looking at. And we think this is a quite innovative idea. We will see, it's a bit of a bet on the future, whether this will pick up as a meaningful service. There's also the question, well, how useful would that be? I mean, don't people rather want data services, or will they find this useful? And we'll have to see that, how the discussion goes on that one. The broader of this for the individuals is what we would call maybe the personal data spaces or personal data stores, or if you're from Finland, a My Data operator, where you have services that help specifically individual to I would say monetize their data, but to find possible uses of their data in exchange for services. And that could be as simple as saying, well, I want to switch maybe between music streaming services, or I think there's a good use to actually, I would like an e-commerce shop to basically offer me suggestions on what I should buy based on my musical taste, because then they say, I'm more this kind of person or that kind of person, and people like this music also wear these type of shoes. So I'm caricaturing a bit. There's obviously also much more serious use cases where you want just to have all your lab results in one place and show it to any doctor that you feel like, without having a hassle of signing in or waiting for dedicated infrastructures to be rolled out. Or even to ingest, if you want, Fitbit data in, well, non-strictly health data in a personal data store situation, which then could be correlated with the more classical health data, which you may find in the future in your electronic health record. So that there could be a broader use also of personal data through these personal data intermediaries. And here again, a strict separation of service, so and especially also a duty to act in the best interest of the individuals. I'll move to the third item, which is, well, can be shorter, which is the data altruism. The data altruism, we had a lot of discussions. What would foster data altruism, and why would people make data available for a good cause or also not? I think it's recognized that, especially in the medical field, where people often see that it makes sense to share information about their own health status and their health path, especially if they have a disease situation which is which is staying with them for a longer period of time, chronic diseases, for example. Then they immediately understand that science needs data, that even pharma companies need data, and the question is, would they be willing to make such available? Also, companies actually sometimes find that it's useful if they would give certain data they have to the community or to the wider public, if you want. And now the question is, how would this be organized? I mean, what type of player do we need to see emerge? And that's what we now try with our data altruism organization, that we say there may be specific not-for-profit organizations that would actually organize the use of such data, which is made available altruistically. Now, here for the data protection experts that may be in the call, we look at two scenarios for the personal data situation. Well, either you have already identified someone who wants to use your data, and this player is able to say the exact purposes for what he will do with the data. That's very fine. Then probably you don't need the altruism organization, because then you would do it in a bilateral setup. And if the player on the other side says, well, I have enough patients or enough data collection points, then I'm fine. But if that person struggles, he or she may want to turn to specialized players that facilitate basically access to data where others have consented to do so. And here, if you look in recital 33 of the GDPR, you see a certain notion that for scientific research, it's accepted that the purposes, the exact purposes of the processing may not be identifiable at the very outset of each processing, and that you have a certain flexibility at the beginning to ask consent for a range of purposes. That's why it's also then called broad consent, not defined as this in the GDPR, but that's what it is commonly referred to. And then some obligations come along to keep the data subjects informed along the way. So this could be a scenario where actually, indeed, and I know it's tried out also in German hospitals as we speak, that you basically are given, you're invited to participate in a situation where you would make available your data for a broader range of cases that are not quite specific, and then a data pool is established, and then these organizations that we're looking for and that would like to register in a public register to get this kind of label of recognized European data altruism provider, that they can then basically administer these databases, and also then be approached by researchers or innovative companies who would like to do scientific research on this basis. So broad consent is limited to scientific research, but as we understand it, not strictly to academic research. So here is maybe some potential on altruism. As you see, we go now very softly. So this is not a regulated, different from the data sharing services, which is a regulated entity, regulated service with a notification requirement and an oversight mechanism. Data altruism remains unregulated as a type of activity, but you can get basically a label by entering yourself in this register in exchange for being transparent about your financial sources and also the way you handle requests for the data reuse. That's basically the solution we found. Now I'm coming to the final point, and now we can maybe still have half an hour of discussion or question and answer. Is the so-called board, the innovation board, has a grand title. It's maybe going to be much more modest. As you read it, probably there's a commission expert group. And I maybe add a fifth point, which is the international dimension, that I still have one other element to explain to you. On the board, a commission expert group, probably with a subgroup structure to have a bit more capacity to discuss a range of topics. Here, it has an instrumental function in, excuse me, in making the regulation work, the reuse requests and how they're harmonized, and the practices of registering altruism and so forth. Then there's also the question to discuss cross-sector interoperability, and maybe also a generic standard question of the data economy. And here we're back to Gaia X, which I mentioned earlier, which is a reference architecture, but also has a standards layer attached to it. And we have similar efforts in Finland by the Finnish Innovation Fund Sitra to come up with a rule book of technical standards for the data economy. And we have in the Netherlands the iShare scheme that is currently applied in the logistics sector, where there's basically a set of agreements that would make them when everyone pledges to comply with these, you don't need any intermediaries to organize your data flows, but you're basically building on an accepted kind of practice underpinned by standards, and that would be good. And what we would like to do here is to bring this to a European level, to see maybe the convergence among those, and then get to a common European data sharing agreement, a standard when there is for the really basic technical questions of how to organize sharing agnostic of any sector, agnostic of any formats, agnostic of any specific rights, but really saying, when we say sharing, what does it mean? What are the roles? What is consent? How is it encoded? What policy option language are we using? There's lots of things that can be done here. That's standardization problem number one. And the second is indeed to find a better way also to maybe identify standardization needs when there's a cross-sector data reuse dimension. This is obviously very, very difficult because A, what is a sector? And second, if you have identified a number of sectors, you can basically have the potence of the number and have the number of combinations that are possible. So this is an infinitely long list that could happen here. So here it's really about saying, well, where are we seeing really potential for reuse across 2 or 3 sectors, and we will then invest maybe the limited money that we can invest as public players into standardization, or encourage industry, but agree on a certain priority. That's so that it's not this is not completely ungoverned, I would say. I'm getting to my final point, which is another international dimension. So we spoke about the question of the highly sensitive public sector data, and what should happen in the international context. I should expand maybe a little bit on the logic there. So here we're speaking about, again, about confidential company data, about also IP protected content, especially. We're not speaking about the personal data because the international transfer of personal data are already covered by the GDPR. But what we're trying to do with this proposal is to inspire ourselves by the, I think, the regime of the GDPR for the non-personal data. And here we would like to make the international data transfer of public sector data, it's really important, conditional on 2 mechanisms. Either we say in the third country, and we will do an implementing act to that effect, IP and trade secrets are protected to an equivalent level to that of the European Union, or we will make the reuser, the company that wants to take the data from the public sector body and take it to a third country, assign an agreement that it accepts to keep the data safe and to respect EU jurisdiction on any dispute where this where IP or trade secret could be a problem. That's the first set of problems we're trying to solve, and the second group of problems is now more on the side of which type of risks are with governmental access possibly to such data, and can we define a certain expectation that we have as Europeans towards third country practices. And this concerns, I think, most visibly, I think, in an industrial context. If you think you shared safely your data under full control, data sovereignty, and so forth through one of these novel data sharing service providers, but in transit, somehow this company, this data sharing service provider, is now put in a conflict situation because it's bound to serve your data sovereignty, but it's also bound by foreign laws that would basically mandate the handover of the data that it transacts on for you as a company. How to solve that conflict, and that's the Article 30 situation. And the Article 30 basically says that you, as a data sharing service provider, but also as an altruism organization, and even as a public sector body, you have to do all necessary, and as a reuser of public sector data that you get from Europe, from a European public sector body, you have legal and technical organizational measures in place to basically make it very hard for, or even impossible for, the foreign authority to access the data unless a number of requirements are fulfilled. And that's very important from an evidence perspective and for other law enforcement purposes, including administrative enforcement. I mean, diesel scandals and the like should be possible in the future. That's not the idea, to block basically a legitimate international cooperation to enforce laws. But we say, well, either there's specific agreements, international agreements to that effect, in the criminal field and civil field, mutual coexistence treaties, or that's 33. We have a situation where that is not the case, that we don't have a treaty, but the foreign law actually is up to a certain standard of that we set for ourselves. And where did we take the standard from? That we defined here, it's our own e-evidence proposal, which is designed to also allow European law enforcement to access data where there's EU jurisdiction on a case of law enforcement, but where it happens that the data are stored outside the European territory, but still where there's a link established between the data points and the jurisdiction that we have over the case. And that's what we formulated in Article 30 and 3. 34 is then saying wherever you give then data, wherever it's possible to then respond to that request, give only as much as needed. That's, I think, quite straightforward. And 35 is saying if you are confronted with that request and it's possible to inform the companies or the people concerned to which the data pertain, then you shall notify, unless this is obviously not possible in a criminal investigation. Okay, this is quite a mouthful, and I'll now be happy to responding to your questions.
Malte, many thanks. That was not easy to summarize, so we really appreciate it. There's already a couple of questions in the chat. We covered all the different sections of the proposal. I think we'd also like to maybe come back to the international dimension later as well. But on the questions, as expected, there's a question on the overlap with GDPR. I'll read the question because the other participants cannot see it in the chat. It's about when data sharing intermediaries process personal data and GDPR applies, and therefore the DPAs, the national or the other GDPR supervisory authorities, are competent. In this case, the sharing intermediaries will rely on subject access requests and data portability. This will likely require codes of conduct, certification, guidelines, and overall enforcement. So the question is whether the Commission thinks that the supervisory authorities are already equipped for these additional tasks in terms of capabilities and budget, and if and how this has been evaluated during the process.
Yeah, I mean, I can't speculate now on the capacity of the enforcement agencies to do this. It's a huge challenge. I mean, this Monday there was a very interesting half-day seminar at French CNIL to which I participated. Maybe some of you did as well, which revolved around the question: is data portability in itself useful, and how is it enforced? And my question is always: was that so far a big priority for data protection authorities? Maybe not so much, because it's also at the intersection of data protection law and competition law, which was then also the fact why the head of the French competition authority was present in that call. Now, what we try to do here is to really separate the two spheres, and our colleagues in DG Justice were very adamant on both on substance and on enforcement procedure. So all aspects, including whether these personal data sharing intermediaries should be certified under any certification scheme that will be available at some point. Currently, to understand, there's none, which is approved by the Data Protection Board. That is a matter to do there. I mean, we had this discussion whether we want to build in these safeguards and basically say, if you are one of these personal data sharing service providers, you have to have certified all your data processing according to these rules. And our colleagues were saying, well, there are no certification schemes available, so what are we doing here? And anyway, any certification is for specific processing, and it's not for entire service providers. So we had a intensive discussion here. We basically leave everyone working on its thing. The second thing also, indeed, is that we have these cooperation mechanisms now, that the authorities that oversee now a personal data sharing service provider need to consult with the data protection authorities whenever there's a question that relates to, are they complying with GDPR? Are there doubts about that? That's how we're trying to solve the problem. So we're trying not to modify or add any layer of complexity here. The problem that we try to solve is really a question of neutrality and openness of these providers in terms of a competition. It's a competition intervention, if you want. And maybe one of you read an FT commentary on this, I think on Monday, where it was about bashing big data is not useful. Let's rather focus on these new intermediaries. And it was mentioning specifically the solid design of Tim Berners-Lee, which is now commercialized under the Inrupt brand. And it's one of the sharing service providers that we have exactly in mind for this, among a range of others that are active on European territory. And here specifically, I mean, those who have not yet heard about My Data, which is basically the umbrella organization where all these data activists and providers meet, and there's an online event also coming up on the 10th and 11th of this month, of the next month. So also here an invitation. This is quite an intense discussion. There is a certification framework on the Japanese side for such personal data banks, as they would call them. So we feel that this is really an emerging kind of player. Will it be used and useful by citizens? We will have to see. Again, as this is a bit a bet on the future, how the future of the data economy will evolve, but we try to at least offer a certain evolutionary path on this.
Thank you. That was a question from Simon Hania from Uber. We now have another question, still from the chat, from Marcus Drummond. He's asking if the personal data spaces could be administered by civil society, public bodies, or local government. Since in the Data Governance Act, the question says, it seems that the definition of data intermediaries seems to presuppose that they are for-profit businesses, while data altruism organizations are non-for-profit.
Yeah, I mean, yeah, I'm following this discussion now, I would say, for 5 years, and that question always came up. I mean, should the public sector have a stronger role? I mean, I was in a panel last year where there was a question: should maybe health data cooperatives come up, and if so, would there be a strong public role? And I think in Germany, there's still a discussion whether there could be like a hybrid situation where also public infrastructures underpin sharing of personal data. It's I think it's fairly legitimate, and the question is then, how would we are the problems that we try to solve under these proposals already covered? Because the public sector is never, let's never say never, but it's normally not supposed to do background monetization on your data and trying to compete with own data services next to the market, but maybe we need to look at that as well. For the moment, we see very limited efforts. We understand that the Flemish government tries to team up with Solid, but I haven't seen the exact setup and design. I also saw that the Scottish government, now that's no longer EU, but still interesting, is teaming up with Midex, which is an established player in the UK on this. So there are certain collaborations with the government, but the question will be, is that then basically under the government brand rolled out, or are you just encouraging and teaming up with a private partner? That has to be seen. So far, our competition problem seems to be more acute with the private suppliers. But by no means we want to prevent the public sector from doing this as well. Thank you for that question, actually.
Thank you. So we have another question that actually also leads us back to the international dimension, as I was hoping to do. And on the international dimension, let's say there's a number of provisions that relate to the transfer of public sector data or the requirements for data sharing intermediaries, and also this this closing provision that seems to apply across the board on access requests. When we talk about public sector data, there is a mention of highly sensitive data, which seems to be something that will have to be defined in the future. And so, we were wondering if you could explain, how would you envisage this definition to take place? Will it be through delegated acts, as it's also referred to in other parts of the same Article 5, I think, or will it be done differently through, full-fledged legislative procedure or something else? And also, if you can maybe give us a little bit of, connect the dots between the different articles that refer to the transfers or the access, because that's actually very, very complicated.
Yeah, and it's been the result of quite intensive work, also creative work, to bridge a bit the gap between what we also understood to be the interest not only of Thierry Breton, but also of Executive Vice President Vestager, to say, well, we'll have to be really careful, and also the Commission President, who is a medical doctor, as you know, because, well, I wouldn't say they're having second thoughts, but they see that as more data come to the fore, and the French case about the Health Data Hub and its choice of Microsoft as the service provider raised some profound discussions in France. As you know, it went all the way to the Conseil d'Etat, and the case is not closed. I mean, there's still the case is still ongoing. We had only an interim judgment on interim measures in that case. So I think health is certainly the example that people think most that are with the data where we should be quite careful when we say health data held by the public sector, again, which is the should go out. I'll first maybe first respond to the distinction between what we call the sensitive data and the highly sensitive data. That's already complicated. In our jargon, we would call everything that is in Chapter 2 are the sensitive data, not to be mixed up with Article 9 GDPR data, by the way, but sensitive because there are rights of others attached to them, and can be companies as well. And these indeed would be usable under the conditions that Article 5 then sets out. And then there is a specific subset of those, of the highly sensitive, but as I said earlier, to come with more severe restrictions on their use. And the article hints that maybe in certain cases it may be justifiable to say that certain highly sensitive data can only be processed in Europe. For that to argue, we would need to see the type of data much more clearly. And that is indeed the future ordinary legislation that will look at this. I think health is certainly on the list. Will there be others? I mean, also we spoke about the questions of how to organize data in the car data space. There was a call in Handelsblatt I read the other day by the German Chancellor to say, yeah, share more, but obviously you want to maybe also make sure that the construction of a mobility data space, if it were a national one in Germany, would be such that these data wouldn't go anywhere. So if there's now I'm wondering a bit, because this is not publicly held data necessarily, this is more privately held data, but it illustrates a bit the problem of the sensitivity, where we push out public sector data again, which is highly sensitive. Future legislation will tell the exact data assets which are considered highly sensitive, and then also we will define the definitions that come with those, because we then can define them. And that's really the context of Article 5 of this adequacy decision situation, or the contractual agreements in, I think it's now 510 actually. The numbering has changed so often that I'm having to look it up here next to me. So that we're in a situation of indeed 5.9 or 5.10. The Article 30, again, on the other hand, is covering everyone. It's not limited to publicly held data, highly sensitive, not sensitive, or no, not sensitive, but it's really saying whatever you feel you're transacting as a company through a data sharing service provider, it should really stay safe, and we really frame governmental access to such data, which really should be for good reasons and according to the right level of safeguards that we describe in Article 30. So I hope that responds to the question. I'm looking at Gerrit's question again. Indeed, so the reuse of the data covered in Chapter 2 will always be authorized by the public sector body in question, or by a competent body. Why a competent body as well? Because in Finland, we have the FinData Authority, which is in a way a hybrid. It takes over it centralizes a number of registers, and we felt that it could be having these mixed functions of advising the small county hospitals, but also doing own data permissions on repositories for it where it's competent. So we have under one roof the two functions. You have own data sets for which you are responsible, and you have also the advice function that we want to give to these competent bodies, or the advice and technical facilitation function with the secure processing environment. I hope this helps a little bit. I think this question will still be with us quite some time.
Yes, we
Sylvia.
have another question from Sylvia, from our colleague from Orgalim, but maybe before moving to that, I had actually another clarification still staying on this. You mentioned this sort of adequacy procedure that would apply also to non-personal data, basically. And so this is 5.9. Does it mean that if there's an adequacy decision to a certain jurisdiction, that automatically expands to the data we're talking about here, or vice versa? I mean, does it mean that if there is no adequacy, the same applies to non-personal data?
No, there's no connector whatsoever, because the problem we want to look at is a different one. This is about the protection of intellectual property and trade secrets, as 5.9a says, and that has to be ascertained separately from the adequacy on personal data. So it's we landed ourselves with a nice task for the future. This can keep us quite busy. As you know, there's a full unit in DG Justice only looking at international dimension of personal data transfer. So we'll see how this will go. But then there's also the mechanism of Article 510, so that the reuser undersigns that it will keep IP protected content and trade secret if ever. I mean, we really also should be very clear. I mean, it's covering an awful lot of cases. That depends certainly how this 5.8 and 5.9 interact with the provision of 5.6. Let me see. Which is basically saying, well, commercial secrets only will go out of the public sector only when the concerned parties has agreed to this. That's the safeguard of 5.6. So to get to 5.9 and 10, you have to have passed through 5.6. And if 5.6 has not applied, you will only see statistical indicators maybe calculated on the basis of commercially confidential information. I mean, I was thinking about import-export statistics where you can design a system that indeed can calculate the volume of toothpaste imported to the European Union, but it should not show it broken down, and should not make it possible also by combining it with other data sets to say this was Colgate or another brand, Unilever brand or other brands. So the data analysis needs to stop when you enter the sphere of commercially confidential information. That's why this verification process under a secure processing environment is so important.
We have another question from, that was a question from IBM, by the way. Now the next is from Silvia Selandari from Orgalim. She's asking, how will the notification requirement and oversight work?
Yeah, I mean, what we try to do here is to make it not overly bureaucratic on process, and also actually, that was our Director General who says we want these measures to actually enter into force relatively fast. Which was a choice to say we're not going through a certification approach where we have to set up first accredited conformity assessment bodies and private certification entities, but that we can basically say, if you feel that you are offering a service covered by Article 9, you send certain information that is required in Article 10 to the national body which is competent, which is designated by each member state to actually oversee these new entities. And then there is an ex post verification mechanism to ensure that the conditions of Article 11 are being respected. And that's Article 13, that you have a compliance verification system here. This was how we we tried to construct it together with the legal service. I hope that answers your question, Sylvia. I mean, probably we'll have also a bilateral with Orgalim at some point, also looking to the future. Yeah.
Thanks
would that answer it?
I'm checking if we have additional questions.
It's slowly towards 10 o'clock, but we can certainly take more questions.
One, I think one other interesting aspect, going back to the sensitive or highly sensitive data, if you have concrete examples that go beyond health data, I think that would be quite interesting.
Yeah, no, I will shy away because apart from health data, nothing has been discussed internally. And again, it has to be data which are, the use of which is highly beneficial, but which is in a public sector database. And that's then narrows down, I think, the choice quite a bit. So we will see. I mean, that I don't want to now openly speculate about any sector that will be added. This is really for, and again, it's for future legislation where you will see the same process as we have it here today. So there will be a proposal by the Commission, consultation on this. And if you are in a sector and you see sector-specific legislation coming, let's say on another data space of some sorts, and you feel that here is as part of this legislation, the Commission says, well, guess what? There are so many interesting data points in public databases, and we now, to make this data space work, we also want to make them usable. Then normally you should say, like, well, flag them and say, well, hey guys, we are the industry and these are our data ultimately, please consider them as highly sensitive. Or if you say, well, no, it would be really useful because we also could actually learn much more on together what these data do. You may also say, no, don't include them on a list of highly sensitive data. So this is, I think, has to be taken much more close to the sectors and the data in the sectors. This is very, very hard to say at my level, which is more like really helicopter view of the data economy.
We had I think last question just came up. It's again from Marcus. It's about maybe if you can help clarify the differences between terminology, data spaces, data sharing services, and data intermediaries. And maybe also, link to that, if you can spend a moment telling us about the Data Act, which will be another proposal coming up, I think, next year. And, how will the Data Act expand on what we have in the Data Governance Act?
Yeah, no, I really appreciate the question, Marcus, if I may, because it's absolutely, I think, important to, disentangle the terms without being too religious about them also. I mean, what we have now here for data sharing services is a definition in Article 9. It describes the type of services that are becoming now subject to a notification requirement and administrative oversight. So this is very important, I think, to see them. For us, they are part of a wider group of data intermediaries, or as I named them, data institutions. If you want to see basically a beautiful designed way to present this, type in a search engine of your choice, data access archipelago, like the islands. And you will see a map from the Open Data Institute, which tries to regroup all the different terms in use in this field of data institutions and cluster them in a beautiful way around certain concepts. And that's shows that there's still an emerging discussion and there's no stable terminology that we could build on. That's why we chose then to use a data sharing service for Article 9, but we call them a bit more broadly than the data intermediaries. So the data sharing services are in fact commercial services which intermediate between a person or company that has data, that has the rights to actually give these data to another party, either because it's data subject himself, or because the company is non-personal data, or there may be a legal basis actually to give this data to another entity, close or far from its own business. So it may be a business partner already, or maybe just some distant, some unknown third party where you put the data on the open space and say, well, maybe there's someone out there and I can still make some money on someone paying me for using that data, and this will be a novel business, and I monetize basically on this. But you need this intermediation element. That's actually quite crucial. So it's about putting the two sides in touch and administrating also that relationship. This distinguishes them, I think, from data brokers as we knew them, which were never actually aiming to link a data holder with a data user and basically channeling your data to the right type of service provider that actually could do something for you with your data. I mean, that's really the important thing. It's not about the interest of the intermediary in our construction should be super limited to actually gain from a transaction type of fee, maybe a subscription-based system. Who knows? The market will tell us that. But to really say, if you want to monetize your data and you don't want to do this as yourself, I can help you. I will put you in touch with people that you need. I can even maybe team you up with others that have similar data, and together you build a strong pool. And only because once you pooled it, the data becomes valuable, because only then you have the sizes that you need for big data and AI training analysis, wherever that's necessary, because alone you are too small, but together you would having a third of the pie, and then you get also a third of basically the revenues from your data pooling, with the overheads of that sharing service intermediary being taken away. But it should be really not that that we have a platformization situation where the new intermediary positions itself in between your data and services, and basically absorbs all the value, but where really it's only facilitates you to find users of data. I think that's again the heart of the concept. And then finally, the data spaces is as well as I tried in the beginning, is an organizational concept. A data space is for us a situation where there are a number of players. The number should be open by design, who say, well, okay, I subject myself to a certain set of legal and technical arrangements that make it for all of us easier and cheaper to transact with our data. Maybe on a platform, maybe on different platforms, maybe even in peer-to-peer, but we all are finding trust and comfort from a certain set of rules that we all apply, and also we can reduce our transaction costs, because certain problems that are commonly cropping up are already solved. And I now exactly know how to encode my specific usage restrictions on that data in this type of standard, which before I had to invent, and there was no one who could use it and who could read out these policy option languages, and no one could actually find an application that basically says when time has elapsed, data no longer visible, or if you don't authenticate as this, no visibility. And we use this authentication system and this type of standard for that. I mean, these type of things we like to see happening within a data space, so that we lower the really basic bottom line transaction problems, and not everyone reinvents the wheel. How the data space will come into existence is really a question. I mean, for certain data spaces, the Commission will do the first shot. That's certainly true for health data, and maybe for a few others, we will have to see with the colleagues. But then there's also basically a call on the industry to say, well, you guys organize yourselves. You don't have to call it a data space. It gives you no benefits whatsoever. But maybe with our standardization work, we can also then give you some of the building bricks in terms of rule books and schemes and as I just described, architectures like Gaia-X, where basically you see, well, this is a good architecture. Let's all use that. Let's not reinvent our own proprietary data sharing architecture anymore. And then you have a data space, and then you define your rules, you define your own governments, and it will be different in each data space, because the setup of the space will be different. The market power of different parties will be different. So the governance mechanisms need to reflect market power and need to have a certain level of fairness, maybe even dispute resolution within the space when there's conflicts over certain behaviors, or even disagreement on how the rules should be designed in the first place. So this is a bit the notion of space, but it has no legal definition so far. The only thing that you can see coming, and we see now a lot of interest, is funding from the Digital Euro program, where there will be a funding line under the high impact project on data spaces to, if you need a Kickstarter in your specific area, and you have now already an ecosystem of players organized, and you want to test this on the Commission, we can certainly host you and see whether, well, then our financial planning can accommodate that type of need. And it happens. I mean, the construction sector has been soliciting some help and saying, well, we could have a construction data space that could really help everyone. I don't know the details. I was not party to that discussion, but I heard about it. And then there will be others where we're discussing mobility data spaces and the rest. I might leave it at this. We are 5 past the hour. It's very exciting and interesting for me to talk about this, but I probably colleagues also have to.
Indeed, I think we could go ahead for another hour probably, but it's 5 past 10. So let me thank you again, Malte Beyer-Katzenberger, for this very interesting discussion. Congratulations again on your adoption of this proposal. Certainly, as ITI, will be very engaged in the legislative process. And also let me thank you, all the participants, all the people that asked questions. I hope this was helpful for everybody. It was certainly very helpful for us. And looking forward to staying in touch. Have a great day.
Thank you, participants, and have a good day as well.